we've had a couple of minutes for people to log in and get going, and we're delighted that you joined us today. And we're happy you're here for today's webinar on defending your intellectual property. I'm Diane Sabato, and I want to just go over the rules of the road. Next slide. This webinar will be recorded, and you'll receive a link to the recording in a follow-up email with any other pertinent information that we would like to include. You will all be muted during the presentation due to the webinar format, but we want to make sure that you all have plenty of time to be able to ask your questions as well. We're aiming for this to be an hour long, with the presentation about 45 minutes or so, and then the remaining time for a block of just any questions that you might have. Attorneys Rick Kozakowski and Mary Bonzani are going to be sharing real stories from the field, together with tactics for defending your intellectual property. Again, we'd love as many questions as you have. Please use the Q&A tool that you see in the bottom. You can use the chat as well. We will be monitoring both. And if it's appropriate, we'll interrupt the presentation with some specific questions. But again, we'll have time set aside at the end of the session for all the questions that you have. This is the second in a three-part webinar series about intellectual property. It's part of STCC's IP Educator in Residence program, which is a joint initiative of the National Association for Community College Entrepreneurship and the Michelson Institute for Intellectual Property. Here's a little bit of background on the people that you see before you on the panelists. John Diffley is a history professor and the honors program coordinator at STCC, as well as an attorney. I'm Diane Sabato, as I said, and I'm a business professor. I have 20 years of experience in entrepreneurship education, and I am a small business owner. Rick Kozakowski is the founder and principal of Swiftwater Law. He's worked for over 30 years in the legal profession, as well as 10 years as a technician and engineer. Rick brings unique insights and business, legal, and technical skills to his work. He's worked with both startups and corporations and law firms that specialize in IP law. Rick's an STCC graduate who earned his subsequent degrees going to school at night while working full-time. His professional, his professional career began as an electronics technician with Pratt & Whitney Aircraft, which is a division of UTC. He was later named Chief IP Counsel for Pratt & Whitney in 2002, where he led the IP legal team for the entire company. Rick's been registered to practice before the United States Patent and Trademark Office since 1989. What this means is that he had to pass a rigorous exam, which is specifically for this purpose, in addition to the state bar exam. Candidates must have a science, technology, or engineering degree to sit for the USPTO exam. He's been admitted to practice as an attorney since 1990. In Rick's legal and technical career, he's worked with all types of businesses. His current focus is on working with entrepreneurs and startup founders. He volunteers as a mentor for entrepreneurs and startups with Valley Venture Mentors Program in Springfield and E for All Hoyok. They're both startup accelerator business assistance programs. Mary Bonzani is a partner at Bulkley Richardson in Springfield. She's been involved in drafting, prosecuting, defending, and licensing patents for a wide variety of inventions worldwide. Mary's in-depth experience as a chemist allows her a unique perspective and allows her to provide her clients with both a legal and a scientific strategy. Mary has also been involved in obtaining, defending, and licensing trademarks worldwide. She's a graduate of American International College and Western New England University Law School. Mary is also registered to practice before the United States Patent and Trademark Office. Again, a rigorous accomplishment. Both Rick and Mary have volunteered their time to share their expertise with us today, which we are deeply grateful for. So it is my great pleasure to now introduce Rick and Mary. Thank you. Next slide, please.
Thank you, Diane, for that introduction. And I want to welcome everyone to today's webinar. Thank you for signing up. Before we get into the detailed presentation, I just want to give the obligatory legal disclaimer. All the materials that we will be presenting today in today's webinars should be considered for general informational purposes only, and it's not intended to be specific legal advice from us. Further, no attorney-client or confidential relationship is formed by way of this presentation. So we encourage you to ask questions, but we discourage you to put any confidential information into those questions. If you have specific legal issues that you feel you need to be addressed, then I would suggest you engage with competent counsel. Having put that aside, I'll turn it over to Mary. Next slide, please.
Good afternoon, everyone, and thank you for attending the webinar today. I'm going to be talking briefly about two categories of intellectual property, that being patents and trade secrets. And patents, basically speaking, are a right that is afforded by the federal government to the patent owner to exclude others from practicing the claimed invention for a limited period of time. So patents have different terms. So we have utility patents, and we have design patents, and we have plant patents. For utility and plant patents, the term of those patents are 20 years from the effective filing date. And for design patents, it would be 14 years from the effective filing date. One point that I wanted to emphasize here is that a U.S. patent provides the patent owner with the right to exclude others from practicing the claimed invention, but does not give the patent owner the right to practice the invention themselves. So for example, if you had a patent for a widget comprising components A plus B plus C, and that there was if there was a more basic patent that had issued years prior for the same widget comprising components A plus B, in order for you to practice your claimed invention, you would infringe upon that more basic patent. So for you to obtain the right to practice your own invention, you would need to license those rights from the owner of that more basic US patent. In terms of trade secrets, we can switch to that topic. Trade secrets are basically highly confidential information that provides your business with some economic advantage. And this is information that is not known outside of your business, and it's not readily discoverable. An example would be the formula for Coca-Cola, for the syrup that goes into this product. Now, this particular formula has been held as a trade secret by the Coca-Cola company for, I think, close to 100 years, if not more than 100 years. And the recipe has been written down and has actually been stored in a vault at SunTrust Bank in Georgia, Atlanta, Georgia, since I think at least 1925 until just recently, since it's been moved. But this is an example of a piece of information that is extremely critical to this business. And if it were released or published in any way, it would have an extremely detrimental effect on the business. And that's why the Coca-Cola company has taken such great efforts to protect it and secure it from anyone other than a select number of people within their organization. One other point I did want to make here is that Coca-Cola, by relying upon trade secret protection, was able to extend their protection for all of these years, so close to 100 years. If back in 1920 they had decided to patent that formulation, then that patent would have had a term that would have expired decades ago. And once a US patent expires, the information or the invention that's disclosed in there is free for anybody to practice. So Coca-Cola made the correct decision back in the 1920s to rely upon trade secrecy law as opposed to patent law in protecting the trade secret information. Next slide. Oh, I'm sorry, Rick.
I'm gonna talk about next trademarks, and just in general intellectual property. We can think of it as an umbrella term. and it covers the 4 related yet somewhat distinct aspects of patents and trade secrets that Mary just spoke about, but also trademarks and copyrights. So when we think of trademarks, we think of some type of identifier for a brand, be it a business or a product or a service that you provide. And studies have shown that currently, due to the proliferance of online marketing, each one of us is exposed to roughly about 4,000 to 5,000 trademarks a day through all the media that we encounter. So trademarks are basically their words or their slogans or their design marks, like logos or symbols, like the Nike logo, the swoosh logo, let's say. This logo can be something like "Just Do It" for Nike. And the basic premise is that once somebody selects and starts using a mark in the provision of products or services, be it something that you sell over the internet, that you ship out across the country or within Massachusetts, or you provide services like restaurant services, then once you start using that mark on those goods or services, you have common law rights in the trademarks. You can take that a step further by seeking to obtain a federal trademark registration from the U.S. Patent and Trademark Office, which gives you a lot more expansive and stronger rights. And you can also get a state trademark registration. Each state will allow you to register a trademark with the state. For Massachusetts, it's the Massachusetts Secretary of State. I'll talk a little bit later about defending your trademarks. The last of the 4 areas is copyrights, and copyrights are legal rights that protect creations once they're reduced to a tangible medium of expression. So the term of art that's used is that it's a work. And a work can comprise photographs, it can comprise artwork, it can be the content of your website, it can be other things, music. And with music, it's both the music itself, the notes, and it's also the lyrics that can be separately protectable. So once you have this creation of the mind and you reduce it to a tangible medium of expression, be it on paper or electronically in a computer, you have rights under federal common law to control certain aspects of that work. You can control who copies it, who distributes it, who performs it publicly, other things as well. So, and then also, similar to trademarks, you can file for and obtain a copyright registration from the United States Copyright Office. And when you get such a registration, it gives you some additional legal rights and presumptions. So, and I'll talk more about defending your copyrights in a bit. So I think next slide.
Okay. Thank you, Rick. So we're going to talk about different ways to protect your intellectual property. And let's just, before we start, let's just imagine that you have started a new business, and the name of the business, let's say, would be Wiley Widgets, and that your principal product offering is an animated widget. You've developed a name or come up with a catchy name for your widget. You have software that animates that widget, so you have proprietary source code that would qualify as a trade secret to your business and give you some economic advantage over competitors. You have come up with a website that's quite creative. You have a lot of graphic designs, some videos and the like, displaying your product and promoting it. And you've protected, or you have a domain name obviously for that website. So the question then becomes, you've identified all this intellectual property that has been developed by your company. What is the best way of protecting it? Well, your first option is to secure either a US and or foreign patents for the product and for any embodiments of that product that you've invented over since you started the company. And when you are applying for a US patent, what you are going to do is your attorney is going to prepare a very detailed description of your widget and how it is made and how it operates and the like. And at the end of that patent application, there's going to be a set of numbered paragraphs. And those are the claims and those are your property right. So that's like a deed to a property, a piece of property. In a patent application, the claims are what you're seeking to get a right to exclude others from. And so that application is filed with the United States Patent and Trademark Office. Within a certain number of months, it is assigned to a US patent examiner, and that US patent examiner will read through that application thoroughly and will conduct a search of the Patent and Trademark Office records to see if any other entity, individual, or company has filed an application or owns a patent that's similar, that describes subject matter that's similar to what you are claiming. And if any of those prior art references are detrimental to the patentability of your claims, then that examiner will issue what's called an office action, where he or she will reject the claims in your application based on one or more prior art references. And at that point, the office action is issued to the applicant, and more typically the patent attorney that's representing the applicant. And you have the opportunity at that point of reading through the references, determining just how close they are to what you're seeking to protect, and amending the claims if necessary to distinguish your invention from the prior art. You'll file a response to the office action, and if you're successful in convincing the examiner that what you have is distinguishable over what's disclosed in these prior art patents, then you will get what's called a notice of allowance. And once that notice of allowance issues, you have a certain period of time to pay a base issue fee, and then that application will mature into a US patent. Within a year after you file an application for a US patent, you have the ability to file in foreign countries for the same application in foreign countries. And the way that you want to choose those foreign countries really depends upon what your business goals are. So if you have locations in Canada or Mexico, or say that you plan on selling your product in Europe, or perhaps you have competitors that are located in any one of those countries or regions, then you might want to consider filing a corresponding patent application in those countries. Okay, so next, you can also register, as Rick had mentioned previously, your trademark, the trademark for the business, the trademark for your product. You also want to consider a domain name registration for your domain name. And as Rick mentioned, you have the option for trademark applications to file on the federal level, which is going to provide you with protection throughout the United States, or on the state level. You know, if your business is located in Springfield, Massachusetts, and you plan on only doing business within this geographic region, you might consider just getting a Massachusetts state trademark registration, which will protect you within the confines of the state of Massachusetts. And as Rick mentioned before, as soon as you adopt and use a trademark, you have certain common law rights that you don't need to do anything to obtain. They just instill by way of adoption and use. So another point about common law rights, as soon as you adopt and use a trademark, you should be using the TM designation next to the mark. So that's important because it tells competitors and the general public that you're claiming common law rights in that trademark, even though you don't have a registration at that point in time. All right, so in addition to trademark registrations and patents, you have the option of applying for copyright protection or copyright registration for the copyrightable subject matter in your website. And also, more importantly, the source code that you use to run your product. And the source code, that even though you're getting protection for the source code, and that source code is a trade secret of your company, it doesn't mean that applying for copyright protection or copyright registration that you lose the trade secret status, because the Copyright Office is only going to require you to produce maybe the first couple of pages and the last couple of pages of the source code. So that will preserve your trade secret, the trade secret status of that source code. So in addition to copyright registrations, you also want to identify and safeguard your trade secrets, as we've mentioned before. And one of the ways of doing that is to use non-disclosure agreements when you are going to be disclosing your trade secret information to third parties. So you want the third parties to upfront recognize that there are trade secrets that you're going to be disclosing. Those trade secrets are proprietary to your company and they're owned by your company. And they would also agree that whatever is disclosed to them, that they have certain obligations of non-use and non-disclosure, and a limited use to only use it for the business purpose that's mentioned in that agreement. Along the same lines, you should be using employment agreements with all of your employees, and they should be required or requested to sign those agreements as soon as they are hired. And the purpose of those agreements is to put them on notice that there's proprietary information that they're going to be exposed to, and they have certain obligations to maintain it confidential and not to use it for any other purpose apart from what they do for your company, so their job. I also wanted to mention support tools that are offered by online marketplaces. These are actually free. So there's certainly tools that you should be aware of. A couple of them are offered by Amazon. Amazon, I think, has been a front runner in this area. There is the Amazon Brand Registry, which is a collection of all of the brands that are housed on the Amazon platform. And the Amazon Brand Registry is actually something that is in place to protect the brands of all of the Amazon retailers, so that if a new retailer comes onto the platform and that retailer has brands that are similar to a brand that's already on the platform, then this type of brand registry will pick that up and inform you, the brand owner, of the problem. Amazon Project Zero is another similar platform, but this one actually gives the Amazon retailer the right to go onto the platform and remove any infringing content. So that gives an awful lot of power to an Amazon retailer. So you certainly want to be cognizant of that ability. There's also eBay Verified Rights Owner Program and Alibaba Intellectual Property Protection Platform. And both of these are basically platforms that allow an individual, a brand owner, to file a complaint, and that complaint against a listing that's on their platform. And then they will take that and make whatever investigations they need internally and then report their results to you. And those are only 4. I mean, I'm sure there's more support tools out there. And I think the point here is that you should be familiar with those and what your rights are that are afforded under each of those programs. All right, next slide. So now we're talking about patent infringement, and what I presented here on this PowerPoint slide is a drawing from a US patent. And this is a micro-optic film structure. And what this film structure does, and it's very small, by the way, so it's in terms of thickness, it's only a couple of nanometers thick. So you have these lenses on the top, and you have these either filled recesses or colored posts on the bottom of this optical spacer, which is labeled with the number 5. And what this device does is it projects synthetic images. And these synthetic images have a number of different optical effects. They can float above the film structure. They can appear below the film structure. They can move from below to above or above to below the film structure. And they can also morph from one image to another image. And the best example that I have of this film structure, John, could you, yes, is I'm going to try to do this here. is the $100 bill. And the $100 US bill has a security strip going down the center, and it's a blue security strip. And when you go back to the slide, please, when you tilt the $100 bill from the top to the bottom, the images that are projected by this film structure, which are a Liberty Bell and the number 100, move from left to right, and they morph. So the Liberty Bell goes to the number 100 and then back to the Liberty Bell. And this particular film structure, at least as of a couple of years ago, there has been no counterfeit of the $100 bill since this security feature has been added to the surface. So it's been quite effective. So this is very important technology for this client. Next slide. All right, so let's assume that you're sitting in your office at Wiley Widgets and one of your employees comes in and says, we found a widget that has been being sold by someone on Amazon, and we ordered it, and it just came in. We've been analyzing it in the lab, and we think that it falls within the scope of the claims in our US patent for this widget. What do? You have a number of options. You can do nothing, which is probably not the best option, because if you do nothing to enforce your rights, then the signal out in the marketplace is that your patent is free game. So I would think about that carefully. The next option would be to send a notice letter. You can send a notice letter to the would-be infringer, notifying them of your patent rights, asking them to do their own due diligence to determine whether or not the product they're selling falls within the scope of the claims of your patent. And hopefully such a notice letter will open up a line of discussion between the two parties, and hopefully you can come up with some type of resolution without having to go to court. If you can't resolve the differences, then your option would be to file an action for patent infringement in federal court. Federal courts have exclusive jurisdiction over patent cases. And like I mentioned before, when you're determining whether or not there's patent infringement, the key source to consider are the patent claims. The patent claims would be carved up into features, and then you'd have to determine whether or not the infringing product has all the features that the claim articulates, right? Another option that's available to you in this scenario, where we have the product being sold on Amazon, is a procedure that Amazon has offered called the Amazon Neutral Patent Evaluation. And this is quite attractive because it is very quick and it's cheap. So you file a request for an Amazon Neutral Patent Evaluation, saying that you've been notified that there's a retailer that's selling a product that might infringe your patent, and you request that they look into it. The Amazon people will send that request off to their Amazon retailer, and the Amazon retailer has the option of removing their product from the Amazon platform or responding. And if they choose to respond saying that they don't infringe, then they have to pay $4,000 to Amazon. And at the same time, you as the patent owner has to pay $4,000 as well. At that point, this case is assigned to a neutral patent evaluator, which is typically an outside IP counsel or patent attorney, and they will look at the facts and render an opinion. And if you're successful in that the patent evaluator says, yes, there's infringement, then you get your $4,000 returned to you, and that product is removed from the Amazon platform. If you lose, then your $4,000 is forfeited, and the other party gets to have their $4,000 returned, and they get to keep their product on the Amazon platform. All right, so something to consider if those facts are in your favor. All right, so I did want to talk briefly also about this case that I was involved in just recently, and it involved Crane Security Technologies and in visual physics, and it was filed against a Swedish company by the name of Rolling Optics. And Rolling Optics makes optical film materials, micro-optic film materials like we see on the $100 bill, and they were importing those fill materials into the United States. At that time, our client had a number of US patents, including the one that we just discussed. And so we filed suit, and we said that the fill materials infringed upon claims in all 5 of these US patents. We were successful in getting Rolling Optics enjoined so that they were not entitled to import any of those fill materials into the country. At that point, we were also successful in having the court determine that all of the patent claims that we had raised were infringed, and that the patents themselves were in fact valid and enforceable. And there was monetary damages that were also awarded at the end of the case. So I think that was it for that case that I wanted to mention. So I think we can go on to the next slide. Rick, I'll hand it to you.
Thanks, Mary. I'm going to talk about trademark infringement, how to defend your trademark rights. John, next slide, please. So you've selected a mark and you've started using it on your goods and services that you're providing. So as I said before, you now have common law federal trademark rights. So those rights allow you to prevent others from using an identical or similar mark on the identical or similar goods or services that you're providing. And the first user of that mark on those goods or services has priority rights. But one thing to think about is if you only have common law rights, while they're powerful, they really only protect you in the geographic area that you're doing business in. So if you have some kind of a supply service here in Western Massachusetts and maybe Northern Connecticut, then you find out that someone is using a similar mark on similar goods or services, let's say out in California or down in Texas, you would probably have little opportunity to stop those people in California and Texas from using the same mark on similar goods or services. So you want to think about getting a trademark registration from the United States Patent and Trademark Office. It's fairly inexpensive and quick. I mean, if everything goes well, it takes about 8 months from start to finish, but it'll give you stronger rights. For example, it'll give you nationwide rights to use your mark. If you decide to expand throughout the United States, it can also allow you to stop those infringers in California or Texas. So that's a powerful thing to have. So your business is going well, you're selling products or services, and now you find out someone is using a similar mark on similar goods. So what's the harm there? Well, the harm is potentially great. What's happening is now the consuming public is likely to be confused as to the source of goods or services. In other words, they've come to know your brand of goods or services, and now they see this other brand that looks a lot like yours, but now they're not sure, is it you know, the one they're used to seeing, or you know, is the one they just started seeing, is it connected with the one they usually see? So now they're confused. And what happens is now perhaps these people, the consuming public, they're buying goods or services from someone else. They're mistaken in thinking that it's really you, that's your business that's providing it. So, you know, over time, this is going to do harm to your business. So what are your possible first steps? Well, you could do nothing, hope it goes away, but you know, sometimes it does, but not likely. It's probably going to increase instead of decrease. So the next option would be send a notice letter, or what's known as a cease and desist letter, where you outline your superior trademark rights, you send it to the alleged infringer, and a lot of times that gets them to stop using your trademark on their goods or services. As a last resort, in other words, if you send this notice letter out and the infringer doesn't stop their use of your trademark, you can commence litigation, but it's a lengthy and it can be a very expensive procedure and no guarantees of success. So what are some other things you can do to defend your trademark? Well, if you obtain a US federal trademark registration, you can record that registration with online retailers such as Amazon, eBay, Alibaba, Etsy, like Mary talked about a little while ago. And what this will do is it'll prevent or even stop counterfeit products from showing up on these online marketplaces. And it's a fairly simplistic thing to do, but you need a federal trademark registration to enroll in, let's say, the Amazon brand registry or Project Zero programs. Also, if you have a US federal trademark registration, you can register it with the United States Customs and Border Protection. The fee is fairly inexpensive. It's $190 is the current fee. You send them a copy of your federal trademark registration and you educate the CBP people about your goods. You tell them about the trademarks, you show them the goods. You know, they love it when you send them a little video, whatever, that shows how, you know, what your products are in that. And CBP has the power to detain goods that are coming into the country. They can seize them, they can even destroy the goods. There's a TV show that's on National Geographic on Wednesday nights. It's called To Catch a Smuggler. It's a real life TV show. Most of the time, they're trying to apprehend people coming into the country with narcotics, but once in a while, they'll show how counterfeit goods are coming in, you know, via freight, usually via airplanes into the country, and CBP is there. They check the boxes and they look and see, you know, are these really counterfeit goods? And in fact, a recent episode of the show about 3 weeks ago or so was from last year during Super Bowl week, when the Super Bowl was in Miami, Florida in early 2020. They had a segment on how they were apprehending these counterfeit goods coming into the country. And all told, for that week, it was something like $26 million worth of counterfeit goods were seized in the Miami area. Another thing to think about is domain names. Your URL, oftentimes when you choose a URL for your website, it will include solely or as part of the URL your trademarks, a word mark or whatever. So it's important to register your trademarks, you know, get a federal trademark registration. But sometimes it happens where a cyber squatter will come in and they will beat you and they will register your URL for your website. And so basically that's trademark infringement, but there is a procedure that's been around for over 20 years. It's called the Uniform Dispute Resolution Procedure. It's administered by WIPO, which is the World Intellectual Property Organization in Switzerland, but it's a fairly effective procedure. I went through it myself when I was working for a division of United Technologies in 1999. A cyber squatter jumped in and registered 2 of our domain names, but we went through the Uniform Dispute Resolution Procedure and we were able to get those domain names back for our usage. So next slide, John, please. So now I'm going to talk about copyright infringement. You know, what are the things you can do if you feel someone's infringing your copyright? John, next slide, please. So as I said earlier, you know, the rights and the nature of copyright begin as soon as you create a work. So in other words, you've created something in your mind and you've reduced it to a tangible medium of expression. And again, examples are artwork. Let's say you're a commercial photographer. So the photos you take, as soon as you take those photos, you have copyrights in those photos. Let's say you're a musician, so you write music, and let's say you also write the lyrics for the songs. Well, as soon as you write those down, the words and the lyrics, you have copyrights in them. Your website content, you know, pretty much every website you see has a copyright notice on it, and books, and you know, there's other things as well. Even though it's optional, it's highly suggested that you use the copyright notice, which is the capital C inside of a circle. You can also obtain a copyright registration. It's optional. You don't have to do it, but if you do it, it gives you some additional rights under federal law. And if you do decide to sue an infringer for copyright infringement, you will need a copyright registration to go into federal court and sue that infringer. So now your business is moving along and you you sense or you become aware of someone is infringing your copyrighted work. Let's say you're an artist, let's say, and you find someone is selling knockoffs of your prints online. They're selling it at flea markets or on street corners or whatever, and you didn't give them the permission to create these works. So in other words, what these people are doing is they're reproducing or they're copying your artwork without your permission, and they're distributing it. And those are two of the rights that you get under the copyrights that you can prevent people from doing, along with displaying the work publicly, performing it publicly, and making derivative works. In other words, if you've written a book and now you want to write a sequel, well, that's up to you. You have the right to do that. No one else does. So now you sense or you find out someone is infringing your copyright. What do? Again, you can do nothing, but that could have great harm to your business over time. You could send a cease and desist letter or a notice letter, and that usually will do the trick. It'll get the infringer to stop. Or you can commence litigation, which again could be costly and time consuming and no guarantees of success. And then similar to trademarks, if you get a US copyright registration, you can record it with United States Customs and Border Protection, and they will look for and they will seize infringing goods that are coming into the country that violate your copyrights. So I think Mary's now going to give an example of a copyright infringement case.
Right. So this case is the Yankee Candle Company versus New England Candle Company. And the issue here what relates to Yankee Candle's mall store at the Holyoke Mall in Ingleside. And I'm sure a majority of you have probably visited the Yankee Candle Company at the Holyoke Mall, and you've noticed that it has a very distinctive storefront. It is dark wood. It has a recessed entrance. It has a brass signage over the front door. Inside, there are display cases in that same dark wood that line the perimeter of the store. Within 1 year after Yankee Candle opened its mall store at the Holyoke Mall, its competitor, New England Candle Company, opened a store at the Enfield Square Mall in Enfield, Connecticut, and it looked strikingly similar to Yankee Candle's mall store in Holyoke. And our client's concern was that consumers were going to be confused into thinking somehow that the New England Candle Company was endorsed by or sponsored or in some way connected to Yankee Candle Company. And that confusion was a real concern. In fact, we had evidence after we filed this lawsuit that a customer that went into New England Candle Company in Enfield Mall made a purchase and went to the register and decided to pay by check and made that check out to the Yankee Candle Company and handed it to the cashier, and the cashier accepted it. And that check found its way all the way into the New England Candle Company business checking account. So it was actually deposited. So we had a number of different levels of confusion as a result. But we were successful in this case. We had asked for a preliminary injunction, asking the court to make New England Candle Company stop infringing the copyright. In this case, the copyright was the design of the mall store that was embodied in the blueprints that were used to construct it. And the court agreed and required the New England Candle Company to make certain structural changes to its mall store in the Enfield Square, which it did. And if I recall correctly, it was several years back, but I think that they had they ended up painting the front of the mall store this fire engine red color. And I think they also changed the color of the brass signage above the front door. And there were a couple of other changes that they made. But so that was sufficient, to alleviate or reduce the likelihood of confusion between these two structures. And so that's it. Next slide, John. Thank you.
Okay, so Trade secret infringement or trade secret theft. John, next slide, please. We talked earlier, trade secrets, they protect valuable business information of all types. It doesn't have to be information that rises to the level of something that you could get a patent on. Instead, it could be something very simple, such as a list of your customers and their buying preferences with you. It can be a list of your suppliers and the pricing that the suppliers charge you. It can be recipes, formulas, all kinds of information that's really known only to you, and it gives you, your business, a competitive advantage. So if you take steps to protect the secrecy of that proprietary information, or it's also called know-how, you got to take reasonable steps. That's what the legal standard is. So if you take these steps, then theoretically the legal protection afforded by trade secrets lasts forever. Example, Mary said earlier, the formula for Coca-Cola. So basically, as a business owner, your job should be to make sure you plug the leaks or potential leaks of your information out to the public. Because once your information gets to the public and it was leaked, without any malice or criminal intent or whatever, it just got out because somebody publicly disclosed it inadvertently, then your trade secret protection could vanish. So some of the things to do to protect your trade secrets is mark your documents with the proprietary or confidential stamp. Use non-disclosure agreements or employment agreements, as Mary alluded to earlier. And a big thing is to restrict access, let's say within your business, by your employees and certainly your visitors. You really don't want your visitors walking, let's say if you have a machine shop, whatever, and you're running a proprietary process on your machines in your shop, you really don't want visitors seeing those machines and how the process works. And also, you want to prohibit downloading or copying of your information if possible, because 40, 50 years ago, the primary method of trade secret theft was to have people walk out with drawings or parts or whatever. But today it's mostly done electronically. People are downloading, or they're emailing it to their friends or whatever. And so a key thing is to restrict access. Another thing to do is, in this day and age, people are moving from job to job, employer to employer quite frequently. So a smart thing to do is when we have an employee who's leaving to perhaps join a competitor or to start his or her own business, conduct an exit interview with that departed employee and remind them that, hey, while you worked here for me, you were exposed to certain trade secrets and proprietary information that we have here. And the general rule of law is that, you cannot stop a departing employee from being gainfully employed someone else. And they can use general information that they know or knowledge at their new employer. But on the other hand, they're not allowed to use your proprietary information at their new employer, because, your business would then be at risk. So if you sense that someone, a departing employee or someone else has stolen your trade secrets or misappropriated them, you can sue under state laws. Massachusetts has laws. There's also federal laws. There's the Economic Espionage Act under federal law. And these laws provide not only civil penalties, in other words, monetary fines, but they also provide steep jail sentences too if the person is convicted of stealing your trade secrets. So, Mary?
Yes, so I was involved in a case several years ago that was brought by Crane & Company against Gregory Jordan. And Gregory Jordan was a former employee at Crane & Company. And he left his job in June of 2013. And within 10 days of him leaving his job at Crane, he filed a provisional patent application with the United States Patent and Trademark Office. And the invention that was described in that application was something very similar to what he was doing at Crane. And we were not made aware of it until that application was converted to a regular application and then published by the United States Patent and Trademark Office, within 18 months. So at that point, the application was published. The trade secret information that was disclosed by way of that patent application was gone. So that was the detriment to Crane, that this trade secret information that they had relied upon was disclosed, intentionally disclosed by a former employee, and there's no way to recapture that information now that it was public. So they were then in a position where they had to negotiate with Mr. Jordan to try to obtain an assignment of his rights in his application from Mr. Jordan to Crane and Company. So that case ultimately settled. But the point here is that even if you take all the steps necessary in educating your employees, there's always going to be that situation where you have somebody that leaves your employee that intentionally discloses your trade secret information. So you take all the steps that are available to you to prevent that, but sometimes it will happen. Right, next slide.
Okay.
That's it.
Okay.
Okay, we have about 10 minutes for questions that people may have, and I know that there was one in the Q&A, John. Oh, sorry, you're muted. John, you're muted.
Of course I am. I had the kids in the background earlier, sorry. So while waiting on a patent registration, are you legally able to start a business and actually selling the products? And I would add to that, what's the dangers of that, as related to defending your patent? So if you've applied, but can you start selling? Should you? What are the drawbacks to that?
Yeah, I'll take that. Yes, you can. You can start selling products. A patent is not something that you must have before you can start selling products. If you decide to start selling products, you usually look at what you're trying to sell and you do what's called a patentability search, and you see if you could possibly get a patent on your product. And for you to get a patent, you have to meet the two main criteria of novelty and non-obviousness. In other words, novelty means that your product cannot have been described in another patent or any type of other document, online, a scientific journal article or something, anywhere in the world, because that's the body of knowledge. It's the body of prior art that exists out there. And for you to get a patent, even though the US patents are only good in the United States, in other words, if you want to get a patent in China or UK, you have to go there. But the prior art can exist anywhere in the world, and your invention has to be patentable over that prior art. So let's say you do a patentability search and you don't, you feel that you won't be able to get a patent on this. But on the other hand, there's no valid enforced patent out there that currently exists that you would be infringing upon. So you decide, okay, even though I can't get a patent on it, I'm going to go ahead and make and sell the product. And you're perfectly okay to do that. You're not violating anything at that point. But if you file a patent application, then you can use the designation patent pending in your marketing literature. And then if you're fortunate to have a patent issue later on, you change the designation to say this product is covered by the following United States patent, and you give the number 10,000,123,456 or whatever. We're approaching 11 million patents now that have issued since they started numbering patents back in the early 1800s. So
I would only add to that some of our clients are only interested in clearing their product. So we conduct what's called a freedom to operate search, where we find out if there's any valid enforceable patents out there that might cause a problem with respect to that product or process. And we render an opinion at the end of our review of the relevant patents and pretty much give them a green light or a red light. And if there are problematic patents, then there's ways to design around those patents. and we provide them with our opinion as to the best way to change their product to design around any problematic patents that we've uncovered.
Mary, are they doing that with the intention of just being first to market or to file for the patent themselves, or both?
So for the clients that would prefer just to have a freedom to operate search conducted, they're not interested in getting patent rights in that product.
Okay.
They just don't want to introduce the product in the marketplace and then get a cease and desist letter from the owner of one of these uncovered patents.
I have an additional question. There are a lot of canned legal documents out there. Is it acceptable, or do you recommend for or against using canned NDAs, non-disclosure agreements, canned employee agreements, or canned cease and desist letters? I know a lot of our student startup businesses particularly are scraping to get by with their startup funds, and whenever they can use it sort of pre-authored, you know, and use their attorneys when they absolutely have to. So just what are your thoughts on that?
Mhm. Rick, do you want to field
Yeah,
that?
you know, a lot of the items or contracts that you mentioned are governed primarily by state laws. So if you're conducting business here in Massachusetts, you really need to look at Massachusetts contract law with respect to NDAs or non-compete agreements or employment agreements, because the laws oftentimes differ with respect to certain types of contracts, even between Massachusetts and Connecticut, let's say, or Vermont or whatever. So if you want to use a canned agreement, I'm sure you can to save money, but on the other hand, you know, you don't want to pick a canned agreement that's based on California law.
Right.
You know, if you're here in Massachusetts, you want, you know,
Yeah.
some type of non-compete agreement that's, say, based on Massachusetts law. So.
Right, because there's templates galore out there on legal websites, and they all look enticing and affordable. And I guess if they could be safely used, I see the merit in them, but that's why I guess I'm asking the question.
You know, once you do have a non-disclosure in an agreement per se that is correct, legally correct, and supportable, that's something that can be used again and again. Right?
Yeah.
So that would be your business template non-disclosure.
Yeah.
So I think it makes sense to, if you find a canned agreement that you think fits the bill, have it run by counsel. Yeah. You know, to have them offer their input and maybe make any changes that need to be made at that point.
Great. So my final question, that for me is a big one, because I face it all the time with students starting up and they're writing their plans and they want to know at what point in the business they get which things. But are you aware of any kinds of insurance that business owners can buy to defend against intellectual property infringement? I've heard tell of patent insurance. And are there ways for them to pay a premium now and not have to have all the funds that it might take to litigate someone infringing on any of your intellectual property? So insurances for that.
Mary, are you?
There is insurance. I'm not, you know, I don't feel comfortable in commenting specifically on the different policies, but I have written agreements where I've required certain insurances be in place to cover any potential liability going forward. So I know it's out there.
Okay.
Yeah, I as well. I know there's patent insurance that'll protect you against patent infringement.
Yeah. I
don't know if a similar type of insurance exists for trademark infringement or copyright infringement. Perhaps, I just don't know. I do know there is patent insurance policies out there.
Yeah. Yeah, we had an example at STCC when we had a student business incubator of students who held a patent. Someone stole their design, stole their ideas, were manufacturing and selling. They just had no means to defend it. And so it sort of came up in the context of that.
Yeah, you know,
we have a lot of startups, so.
You know, Mary made a good point a couple minutes ago about doing these freedom to operate opinions before you get too far down the road with your product designs. Because again, you're looking to see if you have a certain design on paper of your proposed product, would it infringe some active patents out there? But the way patents are asserted against companies and businesses it's not cut and dry. It's, you know, it's the claims portion of a patent that's asserted against the alleged infringer. And those claims have to be read, they have to be understood, they have to be interpreted. And like anything that's surrounded in or comprises words, it's open to different interpretations. So,
Yeah.
you know, you can think that you won't infringe and you go ahead and you make this product, and here comes a patent owner, and this patent owner may not be your competitor, but it could be what's called an NPE or a non-practicing entity.
Mhm.
These are companies that they don't make any product, but all they do is sue. They sue companies. They're trying to extract a royalty or payment. It's almost extortion from these companies. And this, what they call NPE litigation, is booming in the last couple of years.
Wow.
So it's, you know, insurance could come in handy because the price of these lawsuits to defend it is astronomical.
So I think a lot more challenges and questions may come up when it comes to copyright. So if a student wants to start a business and they want to use images and print them on a t-shirt, or sayings and print them on a t-shirt, at what point in their planning process should they involve an IP attorney?
And let me jump in. There's a question in the Q&A that's similar. So say if you're opening an online clothing store, when and should you patent your logo, and when, especially if you're going to be sending it all over the country?
So that would be trademarking the logo, getting a trademark registration. And like I said, when you adopt and use a logo or a trademark, you have certain common law rights that instill immediately. But if this is going to be a business, then I would encourage them to register it sooner than later, right? So you don't want to be in a position where other users are using a similar logo in other parts of the country, or maybe even in your trading area, and they predate you. So you want to make sure, number one, that the logo is available for you to use. And if it is, you should get a registration for it soon.
And in terms of copyright, I mean, if you're thinking about using a certain kind of artwork, you should, before you start investing money in screen printing t-shirts or whatever, or putting it on koozies or whatever, you should talk to an attorney, see if that, you know, logo or that artwork is perhaps part of, it's owned by, you know, a movie company, a production company, some artist or whatever, because, you know, you don't want to start investing money printing t-shirts, you know, 10,000 t-shirts that you're hoping to sell on Cape Cod this summer, and come to find out you're using something that's owned by Paramount Pictures or Warner Brothers, who, if, you know, once Warner Brothers gets wind of that, they're going to come and shut you down right away.
Yeah,
So.
absolutely. Well, sadly, we're at the end of our Q&A time. John, next slide, please. So I want to make sure that you're all aware of our next webinar, which is on April 22nd, which is just an open session. Any question about any kind of intellectual property at all that you have, so come loaded with your questions, and Rick is going to be there to answer them to the best of his ability, which has been great so far. Next slide, please. And here is the contact information for all of today's panelists, as well as the Michelson Institute for IP and the National Association for Community College Entrepreneurship, which is where John and I are IP educators in residence. Both of those websites are full of a lot of free and valuable resources on intellectual property education, their videos. All of our webinars are available through them and will be available through the STCC YouTube channel as well once we publish it. I hope that you'll contact us with any follow-up questions that you might have, something maybe we didn't get to today, and prepare for our next session. I want to take again a moment to thank both Mary and Rick for providing us with this amazing expertise. There were some great examples here of actual cases out there, which I think people can relate to. I hope that everyone that's out there with any kind of intellectual property will begin right at the start of your business defending what's yours. And if you haven't yet and you're into the process, it's never too late. So again, thank you all for being here. And we will see you next webinar. Thanks, Mary, Rick, John.
Thank you.
Thank you.
Thanks, Diane and John, Mary.
Thank you, everybody. Thank you.
Thank you.
It was great.
Thanks.